It's always slightly faster than... Okay, go ahead.
Hey, good morning. I'm Chris Parker. This is Kristen Ishihara with the Ishihara and Parker Law Firm here in Longview, Texas. And today we're going to talk about a pretty simple but important topic of what are letters of testamentary. Kristen, where do we see this? What are they? What is going on?
Sure. Well, it's just kind of a weird phrase. So sometimes people call and say, hey, my mom died. I went to the bank and they said I need letters testamentary or a letter saying I'm the executor. Can you write me a letter?
Yep.
And so it's just kind of a weird phrase that we wanted to make sure people understood. Letters testamentary or letters of administration are things that you can only get through the court probate process, which we'll talk about. But it is not really a letter. It is a piece of paper. It's a certificate. You need the certified copy usually to present to somebody. But it is a certificate given from the clerk at the local probate or county court that says you have been appointed as the executor or for an administration as the administrator of the estate, and therefore you have authority to act on behalf of the estate. So what does it mean, Chris, if I've gone into the bank and said and been told that I need to come back with letters testamentary? What can we assume now that we know that?
Yeah, we can assume that account has no co-owner, or those accounts have no co-owners. We can assume those accounts have no beneficiaries, and the bank is telling you, hey, we need guidance. We need you to take that loved one's will, and we need to make it have effect. Telling you need to make it have effect. Sometimes they'll say, hey, I need you to go get an EIN number. And so I'll have these clients they'll go online, they'll go on the IRS webpage, they'll start making their own EIN number, and they get the same question. Do you have letters of testamentary? That's when you hear those words, it all comes to a screeching halt. That will that you have needs to be probated. Remember, a will has no legal effect unless it's probated. Probating the will allow executor to be appointed, which will allow that executor to receive letters testamentary. It is a process that once someone's told you, you will be going down if you want access to those funds.
Right. A lot of times there's just a lot of confusion too because you probably thought that maybe mom had a beneficiary on that bank account or that you were the power of attorney. So why can't you talk to the mortgage company? Yep. Just some reminders would be that a financial or medical power of attorney ends when someone dies. So you are no longer serving as their power of attorney and you no longer have authority to get information on a mortgage, on a car note, on really anything that the decedent owned. And additionally, if you were a co-signer rather than a joint owner on a bank account, that ends at death. And if mom did not have a beneficiary or a POD or TOD, if there's no designation of who that account goes to at death, the account is frozen and they are really stuck waiting for you to present to them a death certificate, the tax ID number, which Chris referenced as the EIN of the estate, which is actually very simple. You can hop online and get it, but it is not enough. Then you also need letters testamentary issued from the court saying you are the executor and you are authorized to handle the estate. Because otherwise, if we consider it from the bank's perspective, what would be wrong with them just giving it to you? Because a lot of times it's like, well, I'm the only kid, I'm the only person. Why can't you just help me out here, bank?
Yeah. They don't know that though. You know that. You know you're right, but the bank itself will not take on that kind of liability or risk. They know there's a system. The system is a probate will that puts someone in charge that person is then responsible to the court for distributing funds correctly. So that's what they're telling you. The other time I see this pop up a bunch is if down the road there's a wrongful death claim or a lawsuit or an inheritance. Sometimes people receive things after death or there's ongoing actions that may be resulting in the death that are going on afterwards, and a third party is going to need those letters so they know who's in charge of the estate, who has the ability to make decisions. So I've seen that pop up a bunch of times. I have clients come in and say, hey, we had no idea this was going on. Apparently dad or mom was part of a mesothelioma lawsuit or something like that. And now we're having problems. They're saying they need someone in charge, and that's code for you need to probate the will to get those letters testamentary.
Yeah. The other word that is, kind of a red flag, I guess, would be estate. So a lot of times you'll just receive in the mail a check made payable to the estate. A lot of times this is a refund of supplemental insurance premiums because those are automatically drafted. Sometimes that's a insurance check. Maybe the roof was damaged or you had
Oh,
home
yeah.
repair going on when someone passed. They will only issue the check to the estate of. Sometimes this is a long-term care reimbursement check. So if someone's receiving care and getting insurance to help cover that, that's done after you've submitted the claim. So there's always going to be kind of an outstanding claim. Those are always going to be issued to the estate. And then all the same things are triggered. So you may be able to get online and get a tax ID number for the estate, but until you are appointed as the executor or as the administrator of the estate and you have those certified letters in your hand, you can't do anything with that check.
Yep. And oddly enough, I've seen a couple times where your loved one's selling a property, they pass away, contract's already been signed. Well, that sale's still going to go through, but now you will have to become in charge of the estate by becoming the administrator or the executor.
Sure. What's the general process? So let's say this has happened to you. You've been told you need or you have a check made payable to the estate of a loved one, or you've been told by the bank you need letters before they'll help you handle the bank account.
Yeah.
What do you do?
Yep. You find an attorney. You bring the death certificate. You bring the last four of your social. The death certificate will have your loved one's social. You bring your driver's license. You meet with the attorney. You agree to hire them. You do an application of probate. The attorney should walk you through the process. Usually involves filing the original with the courthouse within 3 days of a signed application, delivering the original to the courthouse, doing your notice provisions, going to court, unless you're lucky and it's a very simple one or the court is allowing you to waive personal appearance, maybe by Zoom, who knows. They ask you some very basic questions in court. You get appointed by the court if there's no objection or problems. The court will then at that time give you the magic certificate we need, the Letters Testamentary. You do an inventory, you gather assets, you find out the creditors, you either pay or negotiate with the creditors, whatever seems fitting in your case. And then once all is that done at the appropriate time, you distribute the assets according to the will.
Sure. Everything Chris just said is dependent upon you having a valid will that can be probated.
Yeah.
If that's not true, then your tract is a little different. You still have to go to probate court, but that all is requiring that you have hopefully the original will and that you're bringing that to the lawyer as well for them to submit to the court. You also need to be named as the executor in that will. So someone's will would generally say this person is the executor, maybe have a couple of backups, and then talk about who the beneficiaries are as well. But you do need a valid will that appoints you as the executor. What if someone else is listed as the executor?
Yeah, that can be a problem. So if someone else is the executor, we need to find that person, and they either need to serve as executor, or if they're not going to serve, they can decline to serve, they can resign, but then we need to see who the backup executors are. If there are none, then the process will change, and we'll need consent of all the heirs. So things will get a little more complicated. One thing is if your parents did their wills many, many years ago, and you were a minor when they did it, they probably named your uncle, their brother, or a neighbor, or an adult friend who at this time has probably passed away or shouldn't be serving based on age. So if you have parents who are elderly who did their wills a long, long time ago, for your sake of mind, if you're a child in this simple case, you might very well want them to update the wills to make sure that you and your siblings are the backup executors serving at this time.
Yep, absolutely. We do always want to make sure your executor is current because the court is going to look at that last will and testament and try to implement as much of the decedent's wishes as they can. Yep. So if the wishes are 40 years old and it's listed the wrong people, the court doesn't really have anything better to go off of except for this is who the deceased said they wanted to administer their estate. So they're going to do their best to make sure that that person is the one doing it. Reviewing annually your will to make sure that it's current is a good idea. It doesn't mean you need to make changes every year, but certainly every 5 years thinking about whether you need to update that for kids that are maturing and getting older, and all of those things is very important.
And if I'm the adult kid and I know mom and dad in the past have done these documents and I know that we have a relationship where we're open and talking these things, I'd give them a nudge, just say, hey, just because we know it'll fall to me probably, you did get that corrected so that I can handle business.
Yeah, always ask for a copy.
Yeah.
As long as they're comfortable.
You can ask.
Yeah. Probate can take a period of time. A lot of times folks are nervous about how long it will take. So I've been told that the bank needs letters testamentary. What's the soonest that I can get those back to them? And I've gotten the will probated, do you think?
Yeah. Oh, pretty quick. We're very blessed here in East Texas. I mean, here in Gregg County, we're super, super efficient. They run a tight court down at the courthouse. They're a tight ship. Harrison County, Upshur County, Russ County, they all move at a pretty good clip. I don't think there's any reason you couldn't do any of those within, I mean, latest would be 90 days. A lot of them you can do in 30 days. I mean, just depending on court schedule, holidays. But here in East Texas and all the surrounding counties, everyone seems to run a pretty good probate docket. The judges don't mess around. They keep tight ship. They go pretty quick. Bigger city, your loved one resided and passed away in a bigger city, you're going to run into some issues. And we're not talking Dallas, Houston. You're looking at, a year maybe on those easily. Please don't call us on those. Happy to help.
It does make it harder because there are some things you can do in advance of having the letters testamentary, but to actually take action, you need those.
Yeah.
So a lot of times clients will ask like, hey, I'm trying to sell the car. Can I do that now? No, you have to wait until the court has admitted the will to probate and you've been appointed as the executor. Now you actually have in hand what you need to open a bank account, what you need to sell a car, what you need to sell a house. So you are actually waiting really before you can start doing your job until you have those letters testamentary in hand.
I got this check. It's only good for 90 days or 120
Right.
days. What do I do? It's like, well, you can't do anything until we get done with the court process. I'm hoping you're in East Texas because they're efficient and quick.
Yeah, there are some logistical things that you could do depending upon the family situation. You might be able to start working on personal property by agreement, signing up for an estate sale, engaging a realtor. There are some things that you can kind of start the process, but you have no technical authority until you are appointed. So it is a good idea to get into a lawyer fast and talk about whether you need to probate so you can get the process started. But Chris is right. In East Texas, we're very fortunate that it can take as little as 30 days. So it should be able to help you out getting that done quickly.
And sometimes when you talk to the lawyer, you may find out that there's other avenues in full-blown probate. Every once in a while, we're able to deliver good news saying, hey, the bank or institution said X, but sometimes X also means Y. Not always, but there are a few times that we've been able to find alternative methods to get the banks what they want.
Yeah. All right. I think that's probably all that we have today, and we'll see you next time. Thanks, guys. I forget what